Good afternoon, folks. This is your licensed financial advisor, Chris Wolford, and today we're going to talk about estate planning. We're going to talk about two scenarios: what happens when you do estate plan and what happens when you don't. So what is estate planning? Estate planning is the process of determining who receives your assets, who manages your affairs if you become incapacitated, how taxes and expenses are paid, how your family business or investments continue after your death, and how beneficiaries inherit your assets. Estate planning becomes important in two situations: incapacity, you're alive but unable to make decisions, and or death. Now we have testate versus intestate. So testate is when a person dies with a valid will. The will directs who receives assets, who serves as executor, guardians for minor children, and distribution instructions. Example, John dies with a will stating, wife receives the home, son receives investment accounts, and daughter receives the life insurance proceeds. The probate court generally follows the will's instructions. Intestate. So intestate is when a person dies without a valid will. State law determines who inherits assets, in what order they inherit, and who administers the estate. So when you die without a will, you really don't have a plan. So the deceased loses control over how assets are distributed. So that means it's up for grabs, basically, and they decide who can get your assets. All right. So, for example, a person dies unmarried with no will. So, and that can apply in any state. So it's not necessarily according to the deceased wishes. So I can wish for you to get whatever, but if I don't have that in writing or a legal document, then it doesn't matter. The state will, they will choose how that will go. So what happens during incapacity? Many people focus only on death. Incapacity can be financially devastating. Example, stroke, dementia, Alzheimer's, serious injury, or coma. Without proper documents, family members may need court approval to manage your affairs. Essential incapacity documents: you need a durable financial power of attorney, allow someone to pay bills, access bank accounts, manage investments, and handle real estate transactions. Without it, loved ones may need a court-appointed guardianship. Medical power of attorney allows someone to make healthcare decisions if you're unable to do so. A living will specifies end-of-life treatment preferences. Examples, life support, artificial nutrition, and resuscitation. Wills. A will is a legal document directing the distribution of assets after death. A will can name beneficiaries, name an executor, name guardians for children, and direct asset distribution. A will cannot avoid probate. Many people mistakenly believe a will avoids probate. It does not. Probate is the court-supervised process of validating a will, paying debts, paying taxes, and distributing assets. Probate can involve attorney fees, court costs, delays, and public records, depending on the state and the complexity of the estate. Trust. A trust is a legal arrangement that holds assets for beneficiaries. Parties include or involved is the grantor, who creates the trust, the trustee, who manages trust assets, and the beneficiary, who receives the benefits from the trust. And you, as one person, you can be all three. You can be the person who creates the trust, you can be the person that manages the trust, which is the trustee, and you can be the beneficiary too, all at the same time. Benefits of a revocable living trust. A trust may avoid probate, provide privacy, manage incapacity, speed assets transfers, simplify multi-state property ownership. Example, instead of owning a home personally, ownership is transferred into the trust. Upon death, the successor trustee can transfer assets according to trust instructions without probate. Assets commonly included in estate plans: bank accounts, which is checking and savings, and CDs. You can use joint ownership, POD designations, which is payable on death, and a trust ownership. Investment accounts: stocks, bonds, mutual funds, ETFs can transfer through beneficiary designations, TOD registrations, which is transfer on death, and trust. Retirement accounts: 401k, IRA, Roth IRA, and so forth, so on and so on. These pass primarily through beneficiary designations, not the will. Life insurance. Life insurance generally passes directly to named beneficiaries, not through probate, unless no beneficiary exists, beneficiary predeceased the owner, or estate is named beneficiary. Real estate can transfer through joint tenancy, community property rules, wills, trust. Real estate often creates probate issues when no planning exists. Family businesses. Business owners should have succession plans. Questions include: who will run the company? Who will own the company? Will ownership be sold? Or how will heirs be compensated? Without planning, a successful business can quickly become dysfunctional after the owner's death. Succession planning. Succession planning focuses on business continuity. It answers who takes over leadership, who inherits ownership, how ownership transfers occur, and how taxes and liquidity needs are handled. Common tools include buy-sell agreements, key person insurance, trust, and family limited partnerships. Per stirpes versus per capita. These determine how assets pass to descendants. Per stirpes is by branch. If a beneficiary dies before the estate owner, the beneficiary's children inherit their share. Example, parent has child A, child B. Estate equals $100,000. Child A dies before parent but has two children. Distribution: child B receives $50,000 and child A children split the $50,000. This keeps inheritance within family branches. Per capita is by head. Living beneficiaries divide assets equally. Example, parent has child A deceased, child B living. Estate equals $100,000. Under pure per capita, child B receives $100,000. Child A's children may receive nothing. Estate taxes. Federal estate tax. Most Americans never pay it. The federal exemption is extremely high, allowing substantial wealth to pass before federal estate taxes apply. Congress can change exemption amounts over time, making ongoing review important. State estate taxes. Some states impose their own estate taxes, others do not. So it depends on your state. Inheritance taxes. Different from estate taxes, inheritance taxes are paid by the beneficiary in certain states. All right, so common estate planning mistakes. No will, no trust when appropriate, no power of attorney, no healthcare directives, outdated beneficiaries, not funding the trust, no business succession plan, forgetting digital assets, and failing to review plans after marriage, divorce, birth, or deaths. Bottom line, estate planning isn't just about death, it's about maintaining control. A complete estate plan typically addresses 1. Incapacity planning, 2. Wills, 3. Trust, 4. Beneficiary designations, 5. Probate avoidance strategies, 6. Tax planning, 7. Business succession planning, 8. Per versus per capita distributions. The question isn't whether you have an estate. If you own anything of value, you already have one. The real question is whether you or the state will decide what happens to it. All right, so let's look at this scenario here. We have Dave. He's 55 years old. He's married, has 2 adult children, owns a home worth $500,000, has $250,000 in bank and investment accounts, has a $1 million life insurance policy, a family business worth $750,000, and a 401k worth $400,000. His total estate is roughly $2.9 million. Now let's see what happens. Years before his death, Dave worked with an estate planning attorney and a financial advisor. He created a revocable living trust, a will, durable power of attorney, medical power of attorney, living will, updated beneficiary designations, and a business succession plan. His trust stated that if he became incapacitated, his wife would immediately become successor trustee and manage the family's finances. Dave becomes incapacitated at age 60. Dave suffers a major stroke. Because he planned ahead, his wife immediately gains authority to manage his bank accounts. She can pay bills and manage investments. She can make healthcare decisions. The family business continues operating under the succession plan. No court involvement is required. No guardianship proceedings. No family disputes. Dave later passes away. Upon Dave's death, life insurance pays directly to beneficiaries. The trust distributes assets according to Dave's wishes. His son inherits ownership of the family business. His daughter receives investment assets. His wife retains the family home. Because assets were properly titled in the trust, probate is largely avoided. Family finances remain private. Assets transfer quickly, and business operations continue smoothly. Per Sturpey's protection. Dave's son unfortunately passed away several years before Dave, leaving 2 children. Because Dave used Per Sturpey's language in the trust, the son's share automatically passes to his children. His grandchildren receive their father's inheritance. The family branch remains protected exactly as Dave intended. The outcome. The family grieves the loss of Dave, but they are not fighting in court. They're not waiting months or years for assets. They are not arguing over who gets what. Dave's wishes are carried out efficiently. Scenario 2. Dave never planned. Now let's rewind. Same Dave, same assets, same family, but Dave never created a will. He never created a trust, power of attorneys, healthcare directives, no business succession plan, and no updated beneficiaries. Dave becomes incapacitated at age 60 because Dave suffers a stroke. Immediately problems arise. His wife discovers she cannot access certain accounts. She cannot manage some assets titled solely in Dave's name. She lacks authority to make certain financial decisions. The family must hire attorneys and petition the court for guardianship. The process is expensive, stressful, and public. Meanwhile, bills continue arriving. The family business suffers. Dave was the key decision maker. No succession plan exists. Employees don't know who's in charge. Vendors become concerned. Revenue begins to decline. Family members disagree about who should take over. And the business that took decades to build starts losing value. Now, Dave passes away. Now the real problems begin. Because Dave died intestate without a will, the state determines who inherits assets. The family doesn't necessarily receive assets the way Dave would have wanted. Many assets must pass through probate. The probate process takes time, costs money, becomes public record. Family members begin arguing over distributions. Now you have beneficiary problems. Dave forgot to update a life insurance beneficiary from years ago. The insurance proceeds go somewhere he never intended. His family is shocked, but beneficiary designations generally override the instructions Dave may have verbally expressed. No Per Sturpey's language. Remember Dave's son who passed away before him? Without proper planning, questions arise. Do the grandchildren inherit? Does the surviving child inherit everything? State law may decide the outcome rather than Dave. The family ends up spending money on attorneys to resolve the issue. The outcome. The family loses time. The family spends money. The family experiences stress. The business loses value. Relationships become strained. The court and state law make many of the decisions Dave could have made himself. The lesson. Both versions of Dave had the same assets. Both love their families. Both work hard their entire lives. The difference wasn't how much money Dave had. The difference was whether Dave took the time to create a plan. Because when you don't have an estate plan, you still made a decision. You're letting the courts and state law decide for you.